There's lots of software that you have the devices that when you play to create sheet music, that's one way to do it. Or just record it yourself. And so you have the recording. That's how you want it. Stuff you're writing down when you're doing it, that's what does it. Can't product ideas or anything like that. What's it give you? The exclusive right to reproduce, copy, prepare derivative works, change it a little bit to make something else. For example, if I take a screenplay and I turn it into a movie, it's derivative work. Take a book to a movie. If I take a, I play guitar and I have a hex pickup and I can run it into a computer, and when I play it puts sheet music up. I turn the music into sheet music, derivative work. Distribute copies of the work to the public, can't give it out. Perform the work, can't do anything with it. Display it publicly. Powerful rights. They're independent rights. You can license anything independently. They're separate rights. If you guys are going to do freelance work, which is a lot of people in your profession, you've got to figure this out. If I'm going to do freelance work, I own the article. I own whatever work I'm doing. Can I sell it to one or four? Think paparazzis. They sell their images to who? How many times can they sell it? Exclusive or not exclusive? Figure this out for whoever you're working for. Sound recordings, don't worry about it. All right, how long does it last? For 70 years and after your death. Okay. It used to be 50 years. This is, in my opinion, the one thing Sonny Bono contributed to his time in Congress. Okay, 20 more years. There's statutory damages. These numbers are higher now. Sorry, I need to update this. But this is very, very powerful, particularly for the copyright owners, which you guys should be. If you guys are the copyright owners of this stuff, and then you sue somebody, and I mean, what are you out? You know, absent some major recording contract or a movie, you wrote an article, it got put in the paper, big deal. How much money are you really out here? They paid you $1 grand for it. You know, the law says if you do some things, you don't have to prove you lost a dime. The judge can just say, "Bad guys, you're guilty. I'm going to give you $30,000 on the high end." If you can show the bad guys were really bad, they did it on purpose, the judge can give you $150. This is actually $250 now, without you showing you lost a dime. Very powerful. Oh, and by the way, the other side has to pay for your lawyer fees, too. Very, very pro-copyright owner, pro-author. The law is very much designed to protect authors for this. I can show you another case. But you have to have filed a registration. There's something called a Form CO under copyright.gov. It is not hard to fill out. It's actually easy to fill out. In the Form CO, though, it's electronic. It's kind of a pain in the ass, to be honest with you. But if you go online and you pull out the Form CO, that is not a hard form at all to figure out. And if you're freelance work at all, I would encourage you to learn how to do that, because I mean, it's $30 and it can be done online. It's cake. These are the old forms. You can use them, but this is the types of work you perform. But I wouldn't worry about it too much. I use the Form CO because it's the current form. It's pretty good. If you're an employee, your employer owns it. That's all there is to it. Hard and fast rule. You have to have a specific, particular employment contract to change that. If you're an independent contractor, freelance, rules all change. You own it, they don't. Tasani's fascinating case. What happened in Tasani is all the freelance people gave the New York Times permission to use all their works. You know, they had a guild, they wrote stuff, gave it to the New York Times. New York Times said, we're putting all this stuff on the web. The freelance writers, Tasani being one of the leader for this, said, no you're not, because that's not what our deal was. New York Times is, what are you talking about? You gave us the rights to it. Went to court, the judge said, you didn't give them the right to put it on the web. You just gave them the right to put it in paper. Freelance guys, you win. Okay, craziness. But this is how pro-author this kind of stuff is. It really, really protects that kind of stuff.
Doug, what happens after 70 years after the copyright expires?
Belongs to everyone. All rights can't be protected.
So it's considered in the public domain.
Public domain at that point. You'll hear work made for hire. It's complicated, don't worry about it. You guys are reading the cases in your textbook, or most of the time, I think all the time, you're reading something called appellate cases. What that means is that it lays out what the judge said. Usually at the beginning it says, here's what the legal issues are. Or it says, here's what the facts are that go with this case. And here's the law and here's my analysis. At the very bottom, it says, here's what the rule is. Now, here's what the deal is. Kind of how this goes. This doesn't ever happen in the real world that way. I've never had a client walk into my office, sit down, and start reciting, let me tell you what the legal issues are that I have for you. You know, they just don't do that. They walk in and they usually start off with, I've been screwed. You know, or they start off with, I want to screw someone. What you really want to do is, if you're reading some of these cases, there's something called the IRAC method. You learn this in law school, but this is very, very helpful when you're analyzing any of these cases, trying to figure out what's going on. First you want to figure out is, what is the issue? I just wonder whether IRAC's what they teach. The real question is, what's the issue? In the Tassani case, what's the issue? The issue is, and whoever asks the questions, and this is very, very huge advantage if you're good at this for a journalist in particular. If you know how to ask benign, non-threatening, leading questions, you will be it's a very powerful tool. And the benign, disarming questions are the trick. The exact opposite of that is when you ask a question that says something like, so how long have you been beating your spouse? Okay. That's a child's trick. You know, it's a stupid question, but you understand the point. The benign questions are when you watch a skilled interviewer can march someone down a path. And I'm going to do an exercise with that a little bit later. By the way, interrupt me if you have any questions, that doesn't bother me. But the issue in the Tassani case was just that. What was the issue in the Tassani case? Okay. The issue in the Tassani case could have been whether freelance writers gave all their rights to New York Times. Okay, that's probably a C answer. Another issue phrase would have been whether I'm trying to think it was a mediocre issue, whether New York Times held sufficient rights to publish the freelance articles online. It's probably a B answer, B minus answer. An A answer is whether granting rights of publication for the print encompassed online reproductions. It's getting closer to an A answer, and I'm not sure it's a B plus, A minus answer. But you see the point, you start asking the right question. If you ask the right question, you should be able to take the whether off the front. Whether, and then you have the rest of it, and that should give you your conclusion. In this case, we'll call it an A answer, I'm a little unhappy with it. Whether the New York Times receiving, whether the freelance writers, by granting the right to paper publication, granted the right to online publication, granted the right to online publication. If you take the whether off, you get a conclusion. Okay? In that case, the conclusion would have been, yes, they did. You can rephrase it to be, no, they didn't. How you phrase that can determine what your outcome is. Same thing when you're interviewing somebody. There's another mistake people make when they're trying to figure out the issues, and they're trying to walk down this, and I'll do this real quick. Second's the rule. You gotta know what the rule is. And what's the rule? What rules are you applying by? What is it you're trying to get someone to do, say, or find out? The analysis is just applying the issue and the rules together. Conclusion is the conclusion you want to draw. You never want to ask too many questions. There's always one question short before you want to stop to get the conclusion you want. In the legal world, it goes something like, Mike Tyson, this is some funny example. I can't believe I'm getting ready to use this one. You know, he had a unique technique in a boxing ring, shall we say, and he got in a little trouble for it. And say there's people in there, and he's criminal prosecution, and the police officer and attorney is asking one of the witnesses, you know, did you see what happened? He says, he doesn't say, did you see what happened? Because what you're going to say is, yeah, he bit his ear off. Okay, that's what you're going to get. What you want to ask is, you want to walk somebody down that path. You want to say, so where were you sitting? Well, I was sitting on the front row. Could you see the ring? Well, yes, I could. Was anybody in front of you? No, they weren't. You had a clear view of the ring, unobstructed.